First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never, take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this, because, again, it is not appropriate and, frankly, not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, and what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.